Today, the Director of Public Prosecution made an application before the Anti-Corruption Court to withdraw charges against the Deputy President of the Republic of Kenya, Honorable His Excellency Rigathi Gachagua. The court gave her an undertaking to give its ruling tomorrow. The Director of Public Prosecution has been hit hard by everybody that he is trying to exercise powers not provided under the Act or under the Constitution. I want to lay it very clear the position to that effect. We ourselves, presenting Aisha Jumwa and quite a number of people who are charged, after being given the witness statements, we evaluated the witness statements that we have of the complainants, of the accusers, to the Cabinet Secretary and very many others of our clients. Over 30 lawyers, we found out that the evidence that we have does not meet the threshold to take Aisha Jumwa or any other of our clients through the criminal process system. We did invoke Article 157, 6 and 7, to the effect that the Director of Public Prosecution, if given new material evidence that was not there, the Director of Public Prosecution has power to review. We wrote letters. I myself have written more than 13 letters on behalf of my clients, analyzing the evidence presented. The Director acts under Article 157, Article 157.11, that says it is his duty, cardinal duty, to protect an abuse of the legal process. It is his cardinal duty to protect any form of malicious prosecution that has been brought or investigation that has been brought. We invoked Article 157, 11 to tell the Director of Public Prosecution that the CS and very many others, just like the Deputy President, an abuse of the legal process is being put in motion. This is the evidence. The Director of Prosecution looked at that evidence, agreed with us, and in the anti-corruption matter that was facing Waziri Aisha Jumwa, he went to court. Remember, the Director of Public Prosecution does not terminate any matter. He makes an application giving reasons to a court of law pursuant to Article 157.8, which says he can only terminate with permission of the court. And that's what happened today. The Director moved to court in Mombasa. The way he has moved here, we are also pushing the Director to move to Mombasa High Court to terminate the murder trial for one Aisha Jumwa, because the bullet shot the victim, one Aisha Jumwa has never had a bullet, has never run a gun. Number two, the bullet that shot is not an ordinary civilian bullet. So based on the ballistic report and based on the evidence we have produced to the Director, we are confident that the evidence to pin one Aisha Jumwa and others to continue with the matter is contrary to Article 157.11, an abuse of the legal process, abuse of the criminal justice system. So in this one, the Director of Public Prosecution is right. If evidence has been adduced, and this appears every other time, even when judgments in civil matters have been concluded, the civil procedure rules in section order 45 provides for, if there is new material evidence that has been produced the court will open up that matter and allow the new material to be brought, because the essence of a criminal justice system is justice. We have produced that to the Director of Public Prosecution. Remember, the Director of Public Prosecution does not take instructions from anybody. But on terms of withdrawal, he must get permission of the court. We are very certain in the Mombasa matter, the court is making its ruling on the anti-corruption matter for Aisha Jumwa. We are expecting the director to move to court in the murder trial so that it is terminated, because the evidence does not link one Aisha Jumwa to that matter, and it is very clear that it is us advocates who have written to the Director Public Prosecution, just to similar to what Gachagua did. His advocates introduced new evidence to the director, and the director has acted judiciously pursuant to Article 157. And we hope this settles the matter, the debate in the country, that whether the Director of Public Prosecution has power to terminate matters. The Director of Public Prosecution has power to review, and once he reviews that matter, he comes to court, provides evidence, and if the court is satisfied, it is the court that withdraws the matter. It is the court that withdraws under section the CPC section 87A or terminates that matter. So I hope that settles the country, that the Director of Public Prosecution this matter, and on behalf of my client and our client, has not abused his office. Any question?